All right, hello everybody, and thanks for joining our webinar, TEAs, What to Know in 2016. Michael Kester, lead EB-5 Economist for Impact DataSource, and thanks again to everyone for joining. Just as some background, the reason we're doing this webinar now at this time of year is because this time of year is always kind of an interesting time as the states that designate high unemployment areas are changing over their data. Previously utilizing calendar year 14 data, majority of the states are switching over to calendar year 15 data. So there's a lot going on with with the way TEAs are done under the current regulations at this time of year. Besides all of the normal TEA data changeovers and etc., obviously this is also a very interesting time for the EB-5 program in general, and as TEAs continue to be at the forefront of legislative discussions, and there's still a lot of controversy and arguments about current TEA legislation, etc. It's still at the forefront of everybody's mind. So for both of those reasons, we wanted to just kind of touch base with everybody and just provide some thoughts and guidance on TEAs this year and going forward. As kind of background, we're not really going to get into the weeds of unemployment calculations and census share, etc., and things of that nature. This is meant to be more kind of practical guidance, things to keep in the back of your mind, the right questions to ask as you move forward with your current EB-5 projects you have going, and also potential projects you're evaluating for possibly utilizing the EB-5 program for. Similarly for regarding kind of possible changes, legislative changes, policy changes, etc. As of now, there's been nothing has changed. Current TEA legislation, it's still in place. So we're not going to get too big into hypotheticals or discuss kind of the merits of different proposals or thoughts on how TEAs should be administered, etc. But just kind of lay out what's going on. As background on us, we're economists, and we've just we've worked on over 100 EB-5 projects and done hundreds of economic job studies and TEA analysis, etc. So our advice and guidance is kind of reflective of the experience we've had, and is meant to kind of guide your conversations with your attorneys and other professionals as well. There's not a lot of clear-cut guidance from USCIS on a lot of issues, so we're just trying to provide a practical background. And so to kick off a little bit about Impact DataSource, we are an economic and fiscal impact research and analysis firm. We've been around since 1993 and involved with EB-5 since 2010. In our non-EB-5 side of things, we do economic and fiscal impact analysis, mainly for local economic development deals dealing with incentives, tax abatements, things of that nature. So if any of your EB-5 projects, might also have some sort of local incentives that they're looking for, or you have any other projects that aren't involved with EB-5 that you are looking to get potential incentives for, we can certainly help you out with that as well. With our really significant background in economic analysis, our transition to EB-5 was just kind of a natural, seamless transition in which we were able to kind of leverage our background to the EB-5 program. So our main EB-5 services are the job creation studies for regional center projects, and then of course the TEA analysis, which is kind of the main subject of today's webinar. So we've got significant background. We've done over 100 economic studies and helped our clients obtain over hundreds of state TEA letters. We are heavily involved in the industry as well outside of our own client work. We're on IIUSA's EB-5 editorial committee. We are on USA Advisors due diligence team. We also have a lot of free industry tools we've provided over the years to the EB-5 stakeholders as well. Our free online map. We also provide a free TEA review. The mapping tool can take you so far and point you in the right direction, but it's since the TEA question is so important, it's good to have an actual pair of eyes doing a deep analysis on your location to point out any potential pitfalls. So we offer a free TEA review. I know there's some other service providers that will charge for that kind of initial look, but we like to keep the initial look free of charge. So what are we going to talk about in this webinar? First of all, why are we here? Why do we care about TEAs? Why do we care about what's going on currently with the under the current program, and why do we care about potential upcoming changes? And we'll get into the new data that's being used by the states, and also talk about USCIS potentially doing their own policy and regulation changes. And then of course the legislative discussion, which is still obviously TEAs are a hot topic. So again, as of now, there's been no legislative or policy changes on TEAs. So most of the slides are going to discuss the current legislation that we're currently practicing under, but then we'll get into all the legislative stuff as well later on down the road. Thanks to everybody who submitted questions. We'll try to get to those. The ones ahead of time, I'll try to kind of sprinkle those out throughout the webinar where relevant. We'll also have kind of a wrap-up Q&A session at the end as well. If anyone wants to submit questions during the webinar, you can submit a question in your webinar window. We'll try to get it taken care of during this webinar, but if not, we'll follow up with you by email and help you out as best we can. So let's get started into the meat of the webinar. So first of all, why are we here and why do we care? Typically the first question that is asked of someone pursuing an EB-5 project is my project in a TEA? It sounds like a simple question. It's not always a simple answer, but the TEA, qualifying for a TEA lowers the minimum investment from $1 million to $500,000. So that's why it's the first question that's asked. It's typically a make or break issue, since the market is very competitive, and there's so many TEA projects that trying to market $1 million project is, for most situations, is not really feasible. So again, that's why it's usually the first question asked, and such a make or break issue. We often get asked, I'm doing a direct investment. Does that mean I don't have to worry about TEA eligibility? But while direct investment in regional center projects are vary drastically, in other aspects, the TEA rules and guidelines and regulations are the exact same. And then, of course, obviously based on the nature of the program, the overwhelming majority of projects and investments are in TEAs. This data is from 2012 and 2013, showing about 98% of all projects, direct and regional center, were TEA investments, and the more recent numbers are around the same. So very important topic and question, of course. So so let's talk about under the current legislation. There's two ways to make a TEA. There's rural and high unemployment. And there are possibly going to be legislative changes that add a whole other slew of metrics and possible ways to make a TEA, but we'll discuss those later on down in the webinar. So both rural and high unemployment TEAs, the data changes, so you need to be mindful of that, but not in equal increments. First, we're going to talk about rural areas because they're more straightforward, and the data doesn't change as often, and there's much more simple if your project can't qualify as a rural area. So basically, to qualify as a rural area, the project location needs to check off two boxes. The first question is the bigger question: is my project outside of a metropolitan statistical area? If it is, then it has a chance to be a rural qualified area. If that's the case, it also needs to be outside of a city or town of a population having 20,000 or more. So basically, two boxes that need to be checked. The first, outside of an MSA. The second, needs to be in a town or city of less than 20,000 residents. Rural TEAs are much more stable and long-lasting, which is nice. Based on the USCIS guidelines, the population estimate is based on the most recent decennial census, so that's only going to get updated every 10 years. So the next anticipated update to that data would be 2020. And then the MSA definitions, we're not expecting another update to that until 2023. So if you have a project that qualifies as rural, checks both these boxes now, then you know, you're looking pretty good going forward under the current regulations. There's some proposed legislation to expand the rural definition. We'll touch on that a little bit later. So how do you prove your project's in a rural TEA? Unlike the high unemployment areas where you have to deal with the state and getting a state letter, rural TEAs, since the guidelines are so specific and clear-cut, the states are not involved, nor are they allowed to be involved in the designation of a rural TEA. So you should provide your own evidence in your I-526 petitions, your immigrant investor petitions, that the project's location meets those two criteria, checks both those boxes. USCIS will obviously, you know, check as well, but it's good to point them in the right direction and give them the necessary documentation. You know, the majority of projects are high unemployment area projects, so we'll move on to that quickly and talk about that now. So as opposed to the rural projects, the TEA question is not nearly as clear-cut. Here's when we get into talking about labor force statistics, unemployment rates, dealing with state and potentially local authorities if you're in Texas, and that's when we. So in its simplest form, a high unemployment area is an area that must have 150% unemployment rate of the U.S. national average, and this is typically updated annually. The most recent annual year is 2015, so that's the threshold the majority of the states are going off of now, and it's 8%. The U.S. national average in 2015 was 5.3. 150% of that is 8%. So again, we're dealing with the states, and this is where we need the TEA letter to prove that the project qualifies as a high unemployment TEA. And you know, a key takeaway is that states can differ and often drastically in the way they do things with the data they use, when they update the data, how flexible they might be with combinations of census tracts or potentially census block groups, etc. So you know, there's much more going on behind the scenes and with this, and that's why high unemployment areas are such a hot topic now with potential legislation or policy changes. So just to dig in a little bit to the statistics here. So yeah, the new calendar year 15 threshold that the majority of states are using is going to be 8%. That is down from 9.3% last year. Most states have updated their data because the final data piece to go into the whole calculation was finalized in mid-April. So the majority of states have updated it. For example, California has the most EB-5 activity. They just kind of finished getting their website completely updated this morning. So if you have California projects, their website looks to be all ready to go with the data and tools. So moving forward, most states will need to meet, projects in most states will need to meet an 8% unemployment threshold for the TEA. We get this question asked a lot, and one of the attendees asked it as well, was, you know, intuitively, since the threshold is going down, shouldn't that make it easier for you know, you to find TEA areas? You know, last year it was 9.3, this year it's 8%, so things should get easier. Right, well, unfortunately it's not the case. There's a lot of moving pieces going on behind the scenes that go into the final calculation at the census tract level, which the majority of projects have to utilize. Since there's multiple moving pieces, each site really needs to be analyzed on a, you know, on a case-by-case specific basis. So how can we, you know, how do we prove a high unemployment area, and how do we prove that our project is in a high unemployment area, and how is it designated? So there's multiple different areas that can be TEAs. An MSA, a county, or a city in its entirety can qualify. You know, the majority of them, you know, do not. They do not have 150% of the national average rate in their entirety. So that's why in practice, you know, most projects must get down to the census tract level or even beyond to the census block group level to get the TEA certified. If you can, if your MSA county or city does qualify, I mean that's good for TEA purposes anyway, and that's good. You can keep it simple with your TEA. It's usually very easy to get the state letter because you're not doing any sort of calculations or combining of census tracts. You technically have the option to provide your own data at the MSA and county level, but you should might as well go ahead and get the state letter since it's so easy. But again, as in practice, we really have to get down to census tracts and potentially census block groups, and this is where you really must obtain the letter from the state's TEA certifying agency under the current regulations. When combining sub areas and census tracts, this is where a lot of the controversy has come in, and is that USCIS has given this flexibility of determining what areas can be certified and determining the shape of the TEA. So it's really up to the states, as long as an area of census tracts is contiguous and the math is done correctly, they have some flexibility there. Some states are very flexible while others are not at all, so you kind of have to be mindful of the difference between the states and what they will accept and what they won't. This is a really kind of high-level, just simple example of how the mechanics of most projects TEA certifications kind of work. So what we've got here is a map at the census tract level showing census tract boundaries, and the project site marked by that star. The census tracts that are orange are high unemployment census tracts that qualify, that have more than 150% of the national average rate on their own. And the clear tracts, the non-orange tracts, are the lower unemployment tracts. So you can see the project site, project census tract does not qualify on its own, but it has sufficient surrounding high unemployment tracts where we can combine and aggregate those tracts to create a contiguous area of multiple census tracts that does meet the necessary threshold. So again, it's really never that easy or clean. Sometimes it is, but most projects aren't. But that's kind of the mechanics of how a census tract combination would work, and then most states would not have a problem certifying this very reasonable area. So again, USCIS defers to the states on designating the TEA's areas, and while they will defer to them on the shape, they will review very carefully the methodology that was used, that the area is actually contiguous, there's no gaps, and then very importantly, the timeliness of the data that was used in the certification. So this is a big issue regarding TEA issues, is the timeliness of the TEA letter, and it is certainly of great importance. Most projects, it can be difficult because most projects, the first question they ask is my project in a TEA? And sometimes it's very easy to give that answer. Well, yes, it is, and it will look to be in a TEA in the future. But there's usually a pretty significant gap between when you first ask the question, is my project in a TEA, versus when the project's actually subscribing the immigrant investors. So the key thing to realize is that the TEA really comes into play at the time of the investment or at the time of the I-526 petition. So while a TEA might be good now and be okay when you're first getting the process going, it's important to kind of look ahead and think about what's going on with the project, what's the project timeline with the investors and planned investors. So we always get the question asked, does a TEA letter expire? And in short, yes, under the current regulations, they do. And we're dealing with data updates, that are on an annual basis. There is some legislation that will possibly lock in TEAs for multiple years, potentially 2 or 5. I've seen in some different proposals. That might alleviate some of this, but for now, we need to focus on kind of how things are done now. And USCIS does not provide, really good guidance on this issue of how long TEA letters are valid for, etc. So, over our years of working on, many projects and dealing with many, attorneys and other professionals in the EB-5 industry, our general guidance is that, to be safest, you should really consider the TEA letter to be no longer valid once there's new data out there. In short, kind of ask yourself the question, does my letter use the most recent data that the state is using? So again, that's why we're having this webinar around this time, because most states are switching over the data. So it's a very important issue to discuss with your attorneys and other service providers, etc. Using an outdated letter certainly adds a risk factor to the petition. In our opinion, USCIS has mentioned outdated letters, multiple times on calls of being, one of the more common reasons for RFEs. So really something to be mindful about, and especially with how difficult it is to kind of project out when you might, actually get investors for the project. It's important to have a really good TEA analysis done on the location. So what is a current letter, and what's kind of what they're looking for? So the letter really should be reflective of a 12-month period, which almost all states do. You don't want to present a letter that's based on 1 month of unemployment due to, they like to see 12 months, so there's no kind of room for argument of drastic fluctuations. Again, most states are on a calendar year basis. Some are still on a July to June basis. So those states will be updating around October, November, once that 12-month period data is finalized. So again, just to kind of, reiterate, the letter should be current at the time of the I-526 or when the investment is made. And USCIS will be taking a close look at that. Understanding that it's tough because, some states, like, for California, for example, will put in the letter that, the letter is good from, from a year from the date the date of the letter. And I don't have any evidence to the contrary that USCIS, hasn't gone by that, but we would hope that, they would consider that, but yeah, I think it still is certainly best practice, and would eliminate a risk factor just to ensure that the TEA letter is current using at the time of the I-526. So we talked earlier about our updated TEA map. So as the states are updating their data, we're staying on top of it as well. So we have a new map with the most recent data and some new tools as well. So for those of you familiar with it, it'll show the census tract unemployment rates and high unemployment counties as well. And we've added some additional features to make kind of the rural information much smarter as well. So I'll just kind of bring up the map right now. And so for those of you kind of familiar with the old map, it's a little different layout in general. And we also have so it's got the usual census tract unemployment. High unemployment areas are in orange at the census tract level, but we've also added the rural areas to the rural information to be smarter as well. So you can see here, this is kind of the San Antonio-Austin corridor, and you can see the MSA areas are mainly the clear areas, and then the areas, if you read over here on the legend, the blue or the blue-green areas indicate the rural counties. So there's two different levels. Again, remember, we have to check off 2 boxes to be rural. So, for example, if I click on this county here, Blanco County, it's outside of an MSA, just outside of the Austin MSA, so it's outside of an MSA, and it doesn't have any cities or towns greater than 20,000. So the map will let you know that Blanco County is rural in its entirety. So that information will pop up there. But some counties are not rural in their entirety. They do have a larger city or town. So, for example, which is indicated by the blue-green pop-ups. So if I click on this, Kerr County is just outside of the San Antonio MSA. So it's rural in its entirety, except Kerrville City has more than 20,000, so the map will let you know that. And then, of course, it's got the normal scroll-in functions to analyze the census tract information within the MSA. So you can see the orange high unemployment census tracts popping up. Also a link to our free TEA review, and if you want to discuss economic job studies as well, and any questions at all, of course, feel free to get in touch with us. So that's the updated map with some new functionality. Let's see here. So let's get into, so that's kind of covering under the current legislation and current rules, if you want to call them that. So let's kind of get into the more, I guess, fun and controversial aspect of TEAs and potential regulatory changes and then legislative changes as well. So just to kind of keep you up to date on some current events, so USCIS just held a stakeholder call on April 25th. Was more of just a listening session with USCIS requesting feedback on a couple TEA topics, and then also the regional center designation process and indirect job creation methodologies, but we won't touch on that here. So it seems USCIS is hoping to publish new regulations this summer. Anyone's guess if this will actually happen or what kind of new regulations would happen. But they did request feedback on the following: the minimum investment amounts and also the TEA designation process as well. It seems that if the minimum investment amounts are raised, it seems that kind of the consensus view is 800,000 for TEA projects, and I'm not sure if the non-TEA might stay at $1 million. It could potentially go up as well, but 800,000 seems to be the most likely minimum investment amount if any changes are made, and then likely some sort of CPI indexed increase at certain intervals in the future. And they also requested feedback on the TEA designation process as a whole. And I think that would be less likely for anything to happen at the USCIS level there than raising the minimum investment amounts. But again, it's anyone's guess if anything at all would get done with this. Regarding the TEA designation process, there was a lot of kind of back and forth, and I think there's some disagreement on potentially one of the drafts, and it's been a discussion of taking TEA certification away from the states and doing it at the federal level. So there's been certainly some debate and some folks on both sides of the argument there on if the states were removed from the process and the federal government took it over. So it'd be interesting to see what would play out there. I know there's probably a lot of legitimate concerns of how long USCIS is taking to adjudicate I-924s and I-526s and I-829s right now. Obviously, there's some concern on if they took over the TEA designation process as well. If you weren't able to get an answer on your a TEA response for months, that would definitely cause problems since it's such a big question. And right now, the way it's done, the states usually provide feedback pretty quickly. So let's move on to kind of the congressional, the legislative changes. So obviously, it's been a big topic of discussion over the last year. It seems like last year we were having this same conversation at this time of year as well, and there's not really, it's hard to predict any better than last year what might happen. But certainly good to stay on top of what potentially might be happening and kind of what's out there. So, a lot of the bills provided a lot of different kind of potential new definitions of TEA. A lot of different things have been discussed on where TEAs could go. One of the kind of the easier ones to kind of understand is just potentially limiting census tracts to a determined amount of 10, 12, 20 census tracts and just kind of leaving it at that. That's under discussion, which would be very limiting compared to what's done now. Other bills have added other metrics or qualifiers, poverty, income, kind of modeling how the new market tax credit program is done, and then discussions of having it being based on, more in-depth commuting pattern analysis to try to reasonably project where the workers might be coming from. So that's kind of what's being talked about on the high unemployment side. On the rural side, it seems that there could, if or when any legislation takes place, expanding the rural TEA definition seems to be a serious possibility as well. Also interesting discussions of possibly having a TEA qualify based on project type. Manufacturing and infrastructure are the two that have been we've seen in a bill. So a lot of interesting discussion going on. Still, it seems like there's still no real consensus, and there's still a lot of work to be done, certainly, to arrive at any new sort of agreed-upon TEA legislation. This is, based on all this, Maggie Mullane, with our firm, she went through and put together kind of a TEA determination tree, a flow chart. And what you're looking at now is what the current regulations look like, and kind of from start to finish on how you can, what questions do you ask to figure out if your project's in the TEA or not. So currently there's really only the two ways to go, rural or high unemployment. And even that still kind of looks somewhat complicated when you put it down on paper. But she also took a look at the draft bill for MDM 15J40, which is the bill that had all of the multiple different ways to make a TEA as well that we kind of just talked about, with the different metrics and also different types of projects. And here's what that would look like. So, who knows where things are going to go, but the TEA question could potentially get much more complicated. So it's cool to kind of switch back and forth to look at current what could potentially happen depending on how the wind blows. Again, we'll keep you, we're staying apprised of all the potential data that might be utilized in future TEA certifications as well, and staying on top of it. So let us know if you want to discuss anything or concerning these possibilities, even though it's kind of anyone's guess right now what might happen. We also have a blog series that kind of discussed in depth the potential TEA overhaul from last year as well, if you want to do any more light reading on the subject. Some other hot topics we already talked about, the states being removed from the TEA equation and it being taken over by the federal government. We also touched on locking in a TEA designation for multiple years, which I think would be extremely beneficial for everyone, just based on the long EB-5 project timeline and how kind of slow some things can evolve. So I think that would be certainly beneficial and remove a lot of trepidation and uncertainty for decisions that are being made revolving around millions of dollars could be made much more simpler and provide much more comfort. I haven't really heard too much more about this recently, but there's been some discussion of just doing away with TEAs completely and just removing it from the equation and having everybody just kind of go off of a level playing field. I don't know if anyone out there has heard any more discussion about that. It seems like doesn't have much traction anywhere right now. So that's kind of a summary of what's going on currently and what could possibly happen in the future. So just want to delve into a few Q&A questions and kind of wrap things up from there. So first question, can you help certify any area in any state as a TEA? Are there certain criteria you need to look at and evaluate? So the question kind of lends itself to, under the current practices, is it so flexible that you can just, it doesn't matter where you can do the project on the moon and make a TEA out of it? And the answer to that is no. Even in the states that are most flexible, you're still not able to just have the entire state, any project anywhere be a TEA. But under the way things are currently done, each site still needs to be analyzed on a case-by-case basis, and we can certainly help you out with that. But it's hard to give a real cut and dry answer for any state. So again, just important to have a detailed analysis done on each project location. Second question, is there a fast way to get a list of TEAs by state? Do certain states already have pre-designated TEAs? Kind of yes and no. Some states, like California, have a lot of data and they have tools on their website to help you out, but most states don't. And due to the large number of possible ways through census tract combination, etc., states can't really post an exhaustive list of every single possible spot that could be TEA eligible. Move on to the next one. For USCIS to approve a TEA, is it sufficient just to send unemployment reports, or must there be supporting documents? So again, it kind of depends. Again, to back up, for rural TEAs, yes, you really just should provide your own independent evidence that your location checks the 2 boxes we talked about. But for most projects, you're at the census tract level or potentially block group level, you really need the state TEA letter as sufficient proof. So how long does it take to get a TEA letter right now? This kind of backs us up to the question of, or possibly, the debate of should the states remain involved, or should the federal government take things over? And it depends on the location in the state. Some states will turn it around in a day. Some will, take 2 to 3. If you're in Texas, things can get much more complicated because you're dealing with the down to the local level, the city mayors and the county judges, and you might have a project that they've never even heard of EB-5 before, so you have to get them up to speed and get them comfortable with the program and providing a TEA letter, and that could, we've had that take months before. So as part of our free TEA review, we provide get back to you quickly with a thumbs up, thumbs down, plus any other relevant information you might need to consider kind of moving forward. But then and we'll provide you information depending on the location in the state on how long it might take. What new rules will take place, and when will those rules take effect? Yeah, we wish we had the answers to that as well. If anyone knows, please let us know. I'll be happy to discuss. But yeah, I know there's a lot of uncertainty out there, and we'll stay on top of it and try to keep everyone apprised as best we can. I do have a few additional questions to get into from. So hold on just one second. Let's see. So the first question, unemployment data for TEA certification seems available on the Department of Labor's website. Why does the letter say such data is available May 1st? I think this question is kind of getting at why, why do states like California not get their data, finished for the previous calendar year until May 1st, even though, we have the national unemployment rate is set pretty early on, but as part of the census tract calculation, there's multiple data pieces, and the final data piece is not done until April 15th, the mid-April of most years, and April 15th of this year. So it's so there's kind of a disconnect there between when some states update the data versus when it might be completely finalized. Like I said, some states aren't updating, won't be done updating for another month or so as they get up to speed. Second question, will the TEA that has been approved by the state last year still be valid TEA under the new data and the new legislation? That's a good question with a lot of possible answers. I'm assuming, if you just got the letter last year but hadn't actually filed any actual immigrant investor I-526 petitions, then you should certainly get a new letter and get a new letter for any I-526 petitions going forward. If you already submitted it, if you submitted your petitions last year when that data was the most recent, then that should be fine. As far as any new legislation goes, I know there was a lot of talk about potentially any new legislation being applied retroactively, to investors that had already filed, etc. That would be, devastating if that happened. It seems like that talk has cooled off. So, as far as kind of the grandfathering and everything potentially going on, it's tough to say there. But in general, if you're still filing I-526s, then I'd recommend getting an updated letter for those petitions. Let's see, has there been a significant increase in TEA geographical scope to the lower national unemployment rate? Yeah, we already talked about that. Even though the rate went down nationally, it doesn't necessarily make it any easier. It's all depending on your project location. Can we get coverage for EB-5 projects in city, for example? So New York City, is most projects in New York City have been able to obtain TEA certification. New York City has a lot of significant areas of high unemployment, and New York has taken a relatively flexible approach in constructing TEA areas. So most likely, if you have a project in New York City under the current regulations, you're likely to be able to get it certified as a TEA, but still, certainly location specific. Are you aware of any cities that have guidelines in place that define criteria beyond the federal criteria to establish a TEA? I'm, for example, limits on the number of census tracts that can be in a TEA. Certainly, California is kind of the first state that pops into mind. They, even though they certainly don't have to, California limits the number of census tracts you can use to 12. And other states certainly have kind of their own procedures in place where they might not necessarily have a census tract limit in place, but they certainly have kind of their own case-by-case review where they won't allow you to just combine and snake around and create a creative area. So yeah, there's certainly again, each state kind of does things differently. But yeah, some states and then some cities in Texas also will impose kind of a standard census tract limit that they won't allow you to go beyond no matter what. California, of course, being the most relevant of those examples. Question: Why do you say that in most states the unemployment rate will need to be 8% to get a high unemployment TEA designation? Yeah, so to follow up on that, that goes back to, and yeah, that's a good question. I probably should have made that a little clearer in the PowerPoint. Not every state goes on a calendar year basis. Some go on July to June. 8% is the threshold for calendar year 2015. But states that go off July to June will have to go on whatever that average national unemployment rate was for that 12-month period. So it's not 8%. The ones that are currently on July to June, it's a little bit higher. I think it's 8.6% or something like that. So it's state specific. So most states will be on 8%. There's a few out there still going on a July to June basis. Are there exceptions to the 150% rule? No, I mean, unless your project qualifies as rural. If it's high unemployment, you have to meet the 150% rule, kind of no matter where you're at and no matter what time frame the state is going off of. But you have to be able to compare apples to apples. Is it possible to get TEA designation applied to a project where the investment was made in the previous year? If so, how does that affect the letter you have to receive? Data based on the period of time the investment was made. Yeah, so that's a good question. So again, is it possible to get a TEA designation applied to a project where the investment was made in the previous year? So yes, and that's certainly something we get asked. Not a lot, but we've certainly done this a handful of times where since again, the TEA letter comes into play at the time of the investment, it's you need to make sure that the letter speaks to the data that was relevant at the time of that investment. And sometimes we get calls and say, well, we didn't get the letter, but the investment was made last year. The state's already using this newer data, so can you help us get the letter? And yeah, you just have to. We put together the analysis that shows here's the relevant data at the time. and then you try to work with the local authorities to get the sign off on that letter, even though that data is no longer being used currently for future investors. So yeah, we can certainly do that, and have on several occasions. It's just doing the analysis isn't tricky. Sometimes you just have to, you and the attorneys need to explain to the state why, or the local authorities why you're doing, because they might be confused on why you need older data to make a petition to USCIS. I think that kind of wraps it up. Thanks again to everybody for joining. Again, if we didn't get to your question, let us know. We'll look at it and I'll get back to you for sure by email. Just some other resources to have on hand. We have kind of a video series to discuss the map and just some basics on TEAs. Again, the link to the free TEA review, our free TEA map, list of the states that certify, this list of the state agencies that are designated within each state to certify TEAs, and then our EB-5 blog as well. And we'll also post to our YouTube channel a recording of this webinar, and we'll send out a follow-up email to everyone with that link. Again, thanks everybody for joining, and feel free to reach out to me or Maggie or any of our economists for any EB-5 questions. And thanks again.